Good morning, everyone. Thank you for joining us today for our buyback presentation. Today's presenters are Judith Corrigan and John Boorack, who will be telling you everything you need to know about buybacks and interest calculations. If you are joining the presentation live and you're a board member seeking credit, you will automatically receive 3 credits, and it will automatically be added to your Prosper account. You do not need to do anything. If you watch this later as a recording, you do have to submit a training affidavit in Prosper. The handout can be downloaded for your convenience. Just click on the handout tab in the GoToWebinar interface, and you can download it and follow along as they present. So without any further delay, I will present Judith Corrigan. Judith?
Good morning, everyone. I'm very happy to be here with you today. I can't see you, but I'm happy that we're all united electronically, and hopefully we'll be united in person sometime soon. With me is John Boorack. John, do you want to say hello before I begin my opening spiel?
Hello.
As you know, John is the Actuary of the Commonwealth, and I'm the General Counsel of PERAC, and we're going to do this buyback presentation. You know, we keep surveying the boards, and we keep saying, what topics would you like us to present on? And invariably, the 2 top topics are things involving accidental disability retirement and buybacks. And so we aim to please. Last month, Patrice Luby and Ken Hill did an excellent presentation on remands and medical panels. And this month, November, John and I are going to do what we hope will be an equally excellent presentation on buybacks. And so we're going to talk about all the ways people get money back into the system to get service. So if you have test-taking anxiety, you may be coming to the wrong presentation because we have a lot of quizzes embedded on this. I made a quiz for each question. John is a maniacal teacher type, and he has many quizzes. And we wanted to mention that all places mentioned in this presentation should be presumed to be part of the Chapter 32 family. Sometimes it's tough to make up fake names, and I actually used a lot of names from when I lived and worked in Kentucky for many years, Pikeville, Paintsville, and so forth. So, and Prestonsburg, how could I forget Prestonsburg, where my twins were born 23 years ago now. So every locale mentioned shall be presumed to be part of Chapter 32. And although we have 3 slides, 3 wonderful slides devoted to the under $5,000 rule, really we don't want to talk about the under $5,000 rule that much. So in addition to presuming that all locales mentioned are part of Chapter 32, you should also presume that everybody is in a position which has a fixed salary of $5,000 or more, or $5,000, and you should presume, unless it's otherwise stated. I think there's a scenario and a quiz where there is somebody making under that amount, if I remember correctly. So I would like to thank Felicia McGinnis, who is our new Associate General Counsel here at PERAC. She went through all of our opinion letters and came up with these scenarios, and they are based on opinion letters that PERAC has written over the years. Could I have the next slide, please?
Sure.
So as many of you know, I've waxed poetic before, and I will again, about a decision written by Chief Magistrate Hydledge at Dalla, which outlines how you can get credit for non-membership time. And I put it in one of my famous notes, and I've emailed it to some of you. And generally, there are 2 types of service purchases. They come in little buckets and 2 big buckets: the redeposit of withdrawn time and the earlier non-membership time. So the redeposit of withdrawn time is pretty straightforward, but of course there are a lot of issues about it. But in the decision that I referenced by then Chief Magistrate Hydledge, he mentions 5 sections of Chapter 32 where you can buy back time. And I think basically we focus on 3.5 and 4.2c, but we will mention other sections as well. Next slide, please. So you can see the other sections of Chapter 32 most likely to be used to attempt a buyback or have a buyback. And this is not an inclusive list. Nothing in Chapter 32 is ever inclusive, and nothing can ever be ruled out. But these are the things you basically see. We see 3.5, we see 4.2c, and their companion sections right here. And 3.3 is late entry into membership, which we will discuss in one of the scenarios. And it's just, and 3.6c, 3.6d, and 3.8b are kind of a unified whole because they're about redepositing money. So with that, by way of background, let's go to scenario 1, which is on the next slide. So what we're going to do is we're going to present scenarios with all the information we think you need, and then it will be followed by a quiz. And I'm not sure how the quiz mechanism works, but I am sure that Natasha does it very well, and she will tally the results. So scenario 1, as you can see, Mr. Lee is an active employee who became a member of the retirement system in 2012. He's an animal control officer and loves the work since he loves animals so much. Prior to his getting a full-time job, which awakened membership, he worked since 2007 in a job with an employer with the same retirement system. He had no set hours, but a regular stipend. So that's what you have to soak in about Mr. Lee before you take the exam about Mr. Lee. Speaking of animals, I don't want to just get off topic, but we just got a dog on Monday. And the dog is from Mississippi. His name is Dublin. He's a golden retriever, and he hates the cold. I mean, he just goes out of the house to do his business. He goes running back into the house. So hopefully all will be well with him. It's just like having a baby as far as I can see so far. Next slide, please, for the quiz. So Mr. Lee, may Mr. Lee buy back his creditable service from 2007 for his position for which he received a yearly stipend of over $5,000 but had no set hours. As you can see, there are 4 choices, and I believe in each of the quizzes there will be 4 choices. There may be less than 4 in a couple of them, but the first answer is A, yes, under 3.5, B, yes, under 25C3, C, yes, under section 4.2c, D, there is no way for him to do this. So could you take a moment and answer the quiz?
Okay, the poll will launch momentarily, and you'll have about 30 seconds or less to give us your answer. Okay, about half of you have participated. I'm going to give you about 5 more seconds before we close it out. Interesting. No conclusive answer, Judith.
Yes, and you know what? That is very interesting. And I'm glad to see this because we tried to make them sort of not gut bucket questions, as we used to say in college. The answer is actually C. Yes, he may buy it back under 4.2c. And let's explore that for a minute. Section 3.5 is used for buying back service from another board, which you had another board. And so if we look at the code enforcer position, it didn't have set hours. So what we said in the opinion letter to the board must speak with the member to determine an estimated number of hours. Once those are established, the board should add those hours to the hours from his additional part-time work and allow the purchase of creditable service. The code enforces stipend should be considered regular compensation, and retirement deductions should be taken out even after he became a full-time employee in October of 2012. So he can get creditable service. There's going to have to be some work to do about how much creditable service to grant. And it's under 4.2c because it's from the same board. And this can't be emphasized enough. If you're buying back time prior non-membership service in the same place under 42C, you have to have a rule in place permitting such a buyback. So let's look at the next slide, please. So this is just a general overview of buybacks of earlier non-membership time. And again, we're whamming in on 3.5 and 4.2C because they're the most common. And as you know, we're not talking about interest today, basically. But if we were talking about interest, the section under which you're buying back the time is important. Next slide, please. So here's the under $5,000 rule. I think this is the first of 3 slides where we will mention it. The under $5,000 rule really impacts the ability to buy back time, but we didn't want to spend a lot of time on it because the public policy behind the under $5,000 rule was a guy gets $350 a year for being an elected official in the western part of the state for 29 years, and then he gets a job for $150,000 with the lottery in his last 3 years of service, and then he gets a really big pension that's unfunded and not fair. So I think this is the legislature trying to address that issue, but it does come up a lot, and service is no longer available if the position attaches something under $5,000 as a salary. So here's the next slide, please, is just a list of the categories of eligible time. And you can see that Section 3.5 is very limited. Section 4.2C is more expansive. When I first got here 21 years ago, almost 22 years ago now, there was a tendency to graft Section 3.5 and Section 4.2C together. So you had people buying back time under 3.5 to which they were not entitled. But this is the breakdown of the time, and that's just a list. Next slide, please. Okay, and this is, everybody always demands that this Venn diagram be shown. And basically this Venn diagram shows what I just indicated. So it's very interesting, and it really shows you how limited Section 3.5 ambit is. Next slide, please. So before I turn it over to my esteemed colleague for his first scenario, this is Section 4.2C in all its glory. And remember the 2 caveats about this. You had to be excluded by a rule of the board or excluded by the board, and then the board has to have a rule allowing you to buy back this time. So I will turn it over to John Boorack now. John?
All right, thank you, Judith. Now before, next slide, please, yeah.
Sure. I just have a question that did come in about the Venn diagram.
Oh, okay.
In the diagram, temporary and provisional is in the middle. What does that mean for the purpose of buyback?
Could you please get back to the Venn diagram if we could? It's funny that whoever asked this question is on a mental path with John Boorack and myself. This Venn diagram has made the rounds for many happy years, and when we were preparing this presentation, there was somebody wanted to change it. We had a big discussion about it. So this is what it means. If you want to buy back Section 3.5 time, it has to be substitute, it has to be temporary, or it has to be provisional. Those are the 3 ones. However, Section 4.2C lets you do temporary, provisional, part-time, temporary, provisional, seasonal, or intermittent. So the green part, which usually isn't green in these presentations, but we're shaking it up a little, means that you can buy back temporary or provisional time under both sections. That's what it means.
Thank you.
Welcome. So I'm dying to hear scenario 2, John.
Okay, so thank you, Judith. And before I begin scenario 2, about a month or so ago when Judith and I were presented with the topic of the presentation buybacks, we were planning how we were going to do it. And as Judith said, Felicia had gone through and gotten past opinion letters, and we had said, why don't we come up with stories for each individual scenario? So we did. And I think very quickly you'll be able to see the difference between the two writers of the various scenarios. So as we begin with scenario 2, in 2009, Camille Harrison was a candidate for a 3-year term as a town collector. The town collector is paid an annual salary of $6,000. After a hard-fought and contentious selection or campaign, she was elected as the town collector. Once elected, she was instructed to contribute to an OBRA plan instead of the Quabbin Regional Retirement System. And after seeing that she was doing such a wonderful job as the town collector, she ran unopposed in 2012, 2015, and again in 2018. Next slide, please. So in 2015, after securing her 3rd term as the town collector, she met with an employee of the Quabbin Regional Retirement Board, who informed her she was not eligible for membership in the Quabbin Regional Retirement System and could not purchase her prior service until she had worked 10 years in a member unit. Next slide, please. Now, even though she had served 6 years already, she felt something was wrong. So, however, in 2019, 1 full year into her 4th term, and after she has 10 years of service, she met with the executive director of the retirement board, who advised her to seek membership in the retirement system. Next slide, please. And I promise this is the last one. So later in 2019, the retirement board voted to grant membership to Camille Harrison in the retirement system upon proper repayment of the deduction she would have contributed, effective retroactive to 2009. So now with the quiz questions, I have 3 quiz questions coming up. I will give the answer after I finish the rest of the spiel. So the first quiz question: is Ms. Harrison eligible for membership in the Quabbin Regional Retirement System?
This one, they're answering a lot faster than the first question.
Well, I'm guessing it's because there's 2 choices.
All right, I'm going to close it out in about 5 seconds. If any last minute attendees would like to participate, do so now.
Okay, now for this one, I will answer this one immediately. Yeah, she is eligible for membership in the retirement system. So next slide, please. Can she purchase her prior service? And the 4 choices are yes under section 32A6, yes under section 25C2, yes under section 41S, and D, no, she cannot.
Well, we already know one of them.
Yeah, don't pick D.
This one's a tough one. All right, I'm going to give it about another 5 seconds. Fewer of you have voted this time. Okay, thank you.
Okay, and we'll go to the last question before we answer this one.
Okay.
So next slide, please.
Sure. Let me.
And it's a bonus question for extra credit. Would she be considered a post 4212 member?
All right, I'm closing this one out in about 5 seconds. Most of you have voted.
Okay.
You
So
see the results?
next slide, please.
Okay, let me hide the results here.
Okay, so now as Ms. Harrison was an elected official, they get to decide whether they want to join the retirement system or not. They may be excluded from membership in a retirement system based upon if the position pays under $5,000 a year. Now, fortunately for Ms. Harrison, this was not a consideration. And otherwise, in the absence of such rule, they may elect whether or not to become a member of the system by filing a written application for membership within 90 days after the date of assuming office. If they do elect to become a member of the retirement system and later take their money out, they're subject to the same redeposit requirements as everybody else. Next slide, please. So one thing elected officials do not get to do is they don't get to decide retroactively that they want the service for the prior service. So if they do not elect to become a member of the system while they're in office, they may not buy this time back later. However, if they decide to become a member after any subsequent election, which they have the right to do, they may not buy back their prior elected official time. So once they decide not to join the system, that's it. It's a one-shot deal. Next slide, please. There's a provision in Chapter 32 that says the retirement board must correct any errors upon discovery. To show that PERAC is not above the retirement boards, there's certainly a duty for PERAC to correct any errors that it has made. Now, for the retirement boards, the section of the law is Section 25C2 that allows or that requires retirement boards to correct the errors. Now, when Ms. Harrison was first elected in 2009, she was provided erroneous information that she had to join OBRA. The error was compounded a few years later when she met with the retirement board and they told her she could not purchase her time until she had 10 years of service. So the buyback in this case is authorized, and it's authorized under Section 25C2, which I believe was answer B to the other slide. And since the error happened in 2009, when she was first elected, she would not be considered a post 4212 member. Now, does anyone have any questions on scenario 2 before I turn it back to Judith for scenario 3?
So no question specific, well, no, a question just came in, but there was a request, so maybe Judith can answer this, if it's possible to disperse the opinion letters to board administrators.
Sure. That's a good idea. Doreen, you want to write that down? We'd have to redact personal information, of private people, but that's an excellent idea. So we can do that. I don't know what form that can take, but that is certainly something we could do. Thanks for coming up with that, whoever it did.
Thank you. Yes, thank
Doreen
you.
says yeah, thanks.
Yeah. Doreen is real happy about that. So we have.
She's actually sitting, way socially distanced away from me, but she looks extremely excited about this prospect. So good.
And I do have a question. So elected officials only have a one-shot deal to join. So if a city councilor doesn't join but is reelected, is the city councilor allowed to join once he or she is reelected?
Yeah, I'll take that one. Upon a subsequent election, the elected official does have a choice at that time to elect to join the system. If they do, they cannot get credit for the service for the first term as a city councilor. But as long as they keep getting reelected, they have another chance to opt into the system. They just don't get credit for any service when they had not opted into the system.
Could I jump in on this too? This is relatively new, and I came here almost 22 years ago, and 22 years ago it was the advice of PERAC that if you were an elected official and you opted in a subsequent election, you could buy back your time. But around 2012, CRAB decided that several cases to the effect that said, if we allowed that, it would eliminate, it would make the 90-day election window irrelevant. And so that's why that's been closed in on elected officials. But I consider 2012 to be recent, fairly recent, and that's when it happened. We ready for scenario 3?
Yeah, next slide.
I did want to mention, and we don't have to go back to the previous slide, PERAC has a duty to correct errors, and in the Coppola case, we had approved superannuation retirement allowance without knowing the gentleman had been convicted of a crime related to his office or position. So that's where that language comes from, just to share the little facts with it. So this is scenario number 3, and John has clued you into the fact that I'm doing like a paragraph and one quiz, and he's like being a college professor here and making you do a lot of testing. Both ways are good. So Mr. Green is a police officer in the town of Quabbin. Previously, he was a reserve police officer and never a member in the town of Prestonsburg. He would like to buy back his 3 years and 2 months of police reserve service. He made over $5,000 each year, just to drive that home. We're not talking about the under $5,000 thing. Okay, so with that by way of background, and we know what this is generally about, we will take the quiz. Can Mr. Green buy back this time? A, no, because he was never a member in Prestonsburg. Yes, under Section 42B. Yes, but he gets 5 years of service under Section 42B, not just 3 years and 2 months. Yes, under Section 35. I'm very upset I can't vote, by the way. Every time the quiz goes out, it says the panelists may not vote, kind of in big letters, don't you think, John?
All right, give me a second for this one. For some reason, I didn't have that one in. Hold on.
So Natasha,
I'm going to go ahead and launch the poll. If
okay.
everyone, it's going to just say A, B, C, or D. So look at the answers now. A is no, because he has never been a member. Yes, under Section 42B. Yes, but he gets 5 years, which is C, under Section 42B, not just 3 years and 2 months. And D is yes, under Section 35. So which answer would you select? And everyone had already made up their minds because most people have voted. All right, I'm going to close it out in about 5 seconds. For those of you still thinking. Great, thank you. Another split decision.
Yeah, that's good. That's good. And I think this is really interesting. Okay, so the answer is B. You can buy back that time under 42B. And he can only buy the time he has because we're talking, of course, and we're going to be talking briefly about this because there was just a macros presentation about the second proviso of Section 42B involving call firefighters, intermittent or reserve police officers. I'm going to try to go quickly over this because I imagine most of you attended that macros presentation, but no buyback presentation would be complete without mentioning the second proviso of Section 42B. So Section 42B allows for special grant of time for people serving in certain positions before they become a member. And that's why he can buy back the time under Section 42B. As I will discuss, prior to this, the 42B time was granted without cost. But I need to hone in on the 33% of you who answered B, that he could buy this back under Section 3.5. You know, he might be able to, theoretically. First of all, you're always going to get more bang for your buck if you do the 42B, because the 42B gives you a grant of full-time service. But if that were not available for whatever reason, why wouldn't you be able to buy this under Section 3.5? I think in this scenario, in this opinion letter we're basing it on, the Section 3.5 criteria were not met. But remember what we said earlier in the presentation about how hard it is to fit Section 3.5 into anything. It involves only substitute, temporary, or provisional time. So if you can't fit being a reserve police officer into that slot, you're not going to be able to make the purchase under 3.5, and that would only be for the actual time. So that is why B is the better answer. D is possible given a certain set of circumstances. It doesn't matter because you don't. It's about prior service usually. I know because you guys tell us that some people have it in the middle of service. So that's the answer to the quiz about 42B. Let me quickly. Okay, I just wanted to mention that the election buyback case that I mentioned earlier is AWAD, AWAD, versus the Hampshire County Retirement Board, CR 08621. So,
Okay, and I have several questions that have come in as a result of this portion.
Oh, okay. Sure, maybe we will be able to clarify what comes next. That'd be great if we had questions.
Sure. Okay, so if an elected official submits a membership form once elected and then within the 90 days decides not to join, is that possible?
John?
Judith?
No,
Silence.
it says, we don't have an opinion letter for that one, folks. So that will not be in your little package of opinion letter prizes. So you decide to be a member on a prescribed form and then you change your mind. That has not occurred, but I suspect you could withdraw that before the first deduction had been taken. That's a provisional answer, but that's a good question. It's never come up. I like what questions.
Right.
John?
Okay, I have there's several other questions about this topic. Who notifies the elected official that they have a limited time to join?
Judith?
There is no requirement under Chapter 32 to notify the elected official. Is this fair? It may not be, but there's no notice requirement. So nobody has to notify the elected official.
Under what law can the city councilor not be allowed to purchase that time?
Do you want me to do it, John? It's under the AWAD case and its progeny. I personally, my opinion, Judith's opinion, they should be allowed to buy back that time. It was prior non-membership time. However, a series of decisions of Dollar and Crabb said that if you allow them to buy back prior time, you're making that 90-day limitation in section 32A6 meaningless. And nobody is ever supposed to interpret a law to be meaningless. So the short answer is 32A6, which John talked about, gives only a 90-day window of opportunity to enter into the system. And once that 90 days has expired, you've lost your ability to buy back that time under the AWOD case and its progeny.
Okay, next question. What happens if they are not notified? Seems the board should notify the elected official. It's not something a newly elected official would likely know. Kind of answered that.
Yeah, I mean, Chapter 32 is filled with provisions that notification would be awesome, it would be fair, it would be equitable, but it's not required.
In scenario 2, if an error exists after purchasing the service, does the date of membership move back to the time when they should have been approved for membership? In this case, 2009.
I'll take this one. Yes, because the member had inquired about joining the system at that time, but was instructed erroneously at that point in time. There's no reason to not allow the member the rights that they would have had they been provided the correct information initially.
Well, this generated a lot of questions. The law of correct errors says under section 25, the board upon any error shall, as far as practical, correct the record. If it is not practical, then the board can elect not to correct the error. Is that an accurate statement?
Judith?
I believe, I'm about to open this bad boy up, but I will say this. If a board finds an error, they're supposed to correct it. The board has to correct errors when discovered. It says when practicable. If this questioner has a scenario or something, but I think a board, the shorthand that we've always used with 25C2 or 3 or whatever it is that you have to correct an error when it's discovered.
I'm not sure about this one. It says, who would have to take the liability? I'm assuming it's talking about errors.
John?
Well, for which scenario?
Right, I'm not sure. The individual asking that question, can you just type in which scenario you're referencing? And I'll go into the next question. Or maybe the next question will add something. This one isn't from the same person, but it says, which community accepts the liability for the buyback?
Is this under section 42B? Is that what
They don't say. They don't say. Reserve police buyback.
Yeah, I would assume, Judith, that's the one they're asking about, scenario 3.
Okay, John, you want to take that one?
Okay, Natasha, can you repeat the question, please?
As the person who assigns the liability.
It says who would have to take the liability and which community accepts the liability for the buyback. And
okay. Judith can correct this one if I'm wrong, but
okay.
I would imagine that because the person was never a member in the original retirement system, that the community where they're purchasing the time would be liable for the time. That's certainly true under section. That's certainly true under section 3.5 if the purchase was done under 3.5.
Mm-hmm. And it is for the reserve time that they're asking about.
Yeah, and I agree with John, but yeah, I agree with him. This is a very interesting question, and maybe we should do a presentation on liability.
Yeah, because then the next question is also similar. So maybe everyone got a little confused at that particular section of the presentation. It says, does the previous system have to accept responsibility for the time for a 3.8C when they retire?
Yeah, 3.8C is about the actuary, John, assigning liability at the end of a person's career. I will say that under section 3.5, the current board has to take liability. Section 3.5 says shall, so you don't have any choice in the matter. Under section 4.2C, fee, that's prior time in the same system. I think that I agree with John. It's where you buy back the time from that needs to accept the liability in this case.
Okay, and I'm going to cut off questions and let John go, but I have a couple of more, and then I will jump back in later. If no one tells the elected official they can join, if no one tells the elected official they can join, can they not at a later date say an administrative error has occurred and then be allowed to buy back the time going back?
No.
No, because there was no mistake that was made. As Judith said, there's no requirement that the retirement board notify the elected official of their right to join the system. So there was no mistake that was made. If the elected official could prove that a mistake was made, then I believe they would have the right to purchase the time under the correction of errors. But just because they weren't notified, that does not in and of itself make it an error.
And
Like
if a police,
like the elected official in John's scenario, they were outright told the wrong thing, but that's something different.
if a police officer was a reserve in another system and became full-time, but was never offered buyback of reserve or given credit, do they have the right to buy back the time, and who is liable for service?
Okay, we're gonna keep saying that it's the board you're buying it back from that's liable for the service, and I don't think we're gonna take any more liability questions because this presentation we have a lot to get through, and it's not about liability per se.
Right, right.
And maybe this is a great idea for another presentation because.
Oh, I already have a cosign that a liability webinar would be great.
Yeah, that's a great idea, and we're always looking for ideas about what people are really interested in, and this is good. We just
look
didn't
for
do
that
a
second quarter in 2021. And if you can just repeat the name of that elected official case, Judith, one more time.
Sure. It's let me just do this. Let me just confer with my notes here. It is AWAD, AWAD versus Hampshire County Retirement Board, CR 08621, and it was issued on 12/19/14. So it's just a tough case. So I'm going to forge ahead and continue the reserve police officer call firefighter section. Just a brief overview because I think people are pretty familiar with this by now. This is the McAloney case, and until the McAloney case was decided on June 21st, 2013, the purchase, there was no purchase requirement for the second proviso of Section 42B, that a call firefighter, permanent intermittent police officer be permitted a grant of this service. So CRAB changed the rules on June the 21st, 2013, and provided that you had to buy the service. Next slide, please. So as everybody knows from Section 42B, at least until June the 30th, 2009, you could get this service even if you weren't paid. So a question arose as to how much you should pretend the service was worth to pay into the system because CRAB required payment. So PERAC came up with a brilliant $3,000 amount, and we based that on various provisions of the statute. Then Dollar agreed we should make up an amount to base the payment on, but it should be $5,000, which made all the sense of the world. And then CRAB said, no, what's going to happen is if you weren't paid, the amount you pay back is zero. So until June 30th, 2009, you have a class of people who can get service for that they were never paid for, and perhaps they were never called off their list for $0. So if we can go to the next slide, please. So here's our friend, Mr. Gomes, who made his way all to he didn't make his way all to the Supreme Judicial Court. He didn't take it that far, but the retirement board did. And this is the SJC said that you can charge, you should charge for the service. But to briefly mention what happened to Mr. Gomes, he was one of these people that had 3 years of full-time reserve police service. So that was a significant amount of money. And he bought it back from the Plymouth Retirement Board. And in an audit, PERAC said, hey, Plymouth Retirement Board, you're supposed to give that for free. So they refunded the money to Mr. Gomes. And then when McAloney came out, PERAC said, hey, Plymouth Retirement Board and all other retirement boards, you have to charge for the service. And Mr. Gomes understandably balked at this and didn't really want to pay back the money he had already, he had already been refunded. He had paid it once, been refunded, paid it back, now with interest. So he said he didn't want to pay it. Next slide, please. But the Supreme Judicial Court said that 4.2b should be considered to be a measurement scheme, and the requirement for payment is found in Section 4.2c. And this did break new ground involving the under $5,000 rules, because it was always PERAC's position that the under $5,000 rule shouldn't apply to call firefighter and permanent intermittent police officer time, because it was a special grant of time for a distinct group of people. But this kind of blew that away. Next slide, please. So I just wanted to mention Gomes footnote 4, and also Gomes footnote 9, which is not in this presentation. Gomes footnote 9 says, until 2009, the minimal amount of qualifying work for permanent intermittent police officers was $0. So you could make $0 and 0 cents and still get a grant at this time. And now there is a limit on, you have to make at least $5,000. And this actually makes police officers, reserve police officers, call firefighters, and so forth. It makes them have to receive $5,000 in a year, which is not the traditional understanding of the under $5,000 rule, which says that it's position to which salary of less than $5,000 has been affixed. So that's the brief history of 4.2b and the payment thereof. And with that, I will turn it over for scenario 4.
All right, thank you, Judith. So now with scenario 4, in 2000, as a parent of small children in school, Josephine Nazarene was looking to get out of her house and hang around with people her own age for a few hours a day. She found a nice part-time job working 3 hours a day in a town covered by the Quabbin Regional Retirement System. Since she didn't work at least 20 hours per week, she was not eligible for membership in the retirement system. Next slide. Now, in 2008, with her children being much older, the town asked Josephine Nazarene if she would like to work more hours. She agreed and began working 6-hour days instead of 3-hour days. However, the town was negligent and never informed the Quabbin Regional Retirement Board that Josephine Nazarene was now working 30 hours per week and would qualify for membership in the retirement system. Next slide. Now, in 2018, Josephine Nazarene asked about how the retirement system worked and wondered whether she should be a member or not. The retirement board subsequently voted to allow Josephine Nazarene to become a member of the retirement system. In case you haven't guessed, I like saying Josephine Nazarene. So Josephine Nazarene would like to purchase her prior service. So next slide, please. So the first question we have is Josephine Nazarene eligible for membership?
Hold on one second. I'll be launching that momentarily. Yeah, I'm going to give about 5 more seconds.
And for this one, of course, the answer is yes. Once she reached the 20-hour per week threshold, she did become eligible for membership. Next slide, please. So now the next question is can Josephine Nazarene purchase her prior service? And the answers are yes, she can purchase the time all the way back to 2000. Yes, she can purchase the time back to 2008. C, yes, she can purchase up to 4 years of service. Or D, no, she cannot purchase any prior service.
Okay, I'm going to launch that poll. Everyone get your answers ready. A, B, C, or D. Remember which letter you're going to choose. Okay, people were very decisive with this one, so we'll see who's right. 5 more seconds.
And now with this one, the answer is either A or B. And the answer is B. Yes, she can purchase the time back to 2008 under Section 25C. In 2008, she was first eligible for membership at that time once her hours worked per week exceeded the 20-hour threshold for membership. So under 25C, she can purchase that time back to 2008. However, A can also be correct under Section 42C, as long as the board has a rule in place allowing the purchase of that prior part-time membership service. Okay, does anyone have any questions on scenario 4?
Let me see if there's any more questions.
And if not, I'll turn it over to Judith again for scenario number 5.
Hold on, there are a few questions.
Okay.
Just get back to the last question from the Section 42B allows for, in addition to the 5 years, page 93 of MGL chapter 32. So it seems like the purchase of more than 5 years is allowed. Can you speak to this section of the law and what it means?
So page 93.
That's what it's, yes.
Okay, let me.
I mean, I'll start with my basic understanding while Judith is looking up this particular section. Further down in section 42B, there's a local option for retirement systems to allow the purchase of service beyond the initial 5 years authorized under 42B. But the service that's granted beyond the initial 5 years of service, I believe, is done day for day for each day worked.
Yes, I think John is correct. In my book, I don't know if you can see it, I have the word day for day next to that particular scenario. So the second proviso of section 42B, up to 5 years.
Okay.
Thank you for the page number. That was good.
If she was erroneously admitted in 2008, would there be no interest charged?
Judith is the interest expert on this case. So
Yes.
I believe there would be interest charged, but.
You know, there was a case in 2006 in the appeals court Bristol County Retirement Board. I can't remember the rest of the citation. Perhaps somebody will text me the citation. But that really began a whirlwind of things that had happened in the past being viewed as equitable remedies beyond dollar and crab capabilities. And one of those areas was interest. And PERAC is still fighting the good fight in dollar and crab, and PERAC had opined for years, PERA ahead of it, that if you were erroneously excluded, you should not pay interest on a buyback. And then I believe it was the 2006 appeals court case that really set the ball in motion for that to be done away with. And Dallas said that there was no reason that interest shouldn't be assessed on these buybacks. Now, at this point, you know, Section 3.3 allows you to purchase time if you were eligible for membership or you didn't become a member for whatever reason. And that kind of encompasses erroneous exclusion. And there's a Dallas decision saying, look, it says right in it that interest shall be paid. PERAC would say that if you're going to you have to assess interest on an erroneous exclusion, but it should be at the correction of errors rate. And we are in crab right now about this. And I don't know when that decision will issue, but yeah, you have to do interest on just about everything. There's one category without interest, and that's veterans.
Okay, that was the last one.
Okay, we're going to go to scenario 5 now. And scenario 5, speaking of veterans, is about a veteran. And Mr. Quinn was employed by an employer in the Paintsville retirement system and then had service in the military from 1971 to 1973 for a total of 2 years. So he was working in Paintsville, which is a really, really beautiful town in southeastern Kentucky in real life, but Chapter 32 in our presumed presentation scenarios. And he was summoned from that position to military service for 2 years. When he returned home, he got a job with an employer in the Pikeville retirement system, another beautiful city in southeastern Kentucky. He would like to purchase this service and some reserved time. So let's go to our quick quiz. So there are 4 possible answers to this. He can buy it from Pikeville, where he now works under Section 41H. He can buy it from Paintsville, where he formerly worked under Section 41H. The C answer is he doesn't have to purchase it at all, but he does have to purchase his reserve time, or it did say that he wanted to purchase some reserve time. And D, he needs to purchase the 1972-1973 time using a 5-to-1 ratio.
Okay, everyone select which letter you would pick, and we will launch the poll. It's looking like another split decision. About 5 more seconds. Can you see the results, Judith?
I can. 47, 17, 28, and 8. Okay, so this is very good and very thought-provoking. The answer is C. He doesn't have to purchase this military service. When you're working in a municipality and you're summoned to military service, you don't have to buy back that time. It's credited to you, and the municipality should be sending the money for the contributions to the military reserve fund. So he doesn't have to purchase the 2 years from 1972 or in 1973. He does have to purchase, I guess this is a trick question because he does have to purchase from his present employer to the National Guard service, and he would do that on a 5-to-1 ratio. So if we can go to the next slide, it just gives you the quick summation of the rules about veteran service buybacks. This is one case where you must be a member in service to effectuate the buyback. As we indicated, there's a 5-to-1 ratio for National Guard and active reserve time, but you have to establish membership first. And you must, one thing that sometimes trips people up, you have to have been discharged from the service and discharged honorably or under honorable conditions. And we've seen a couple of people who are not considered veterans under Massachusetts law because of that G section. And so when you pay back the military retirements to the board of which you are currently a member in service, and you buy it at the formula described at subsection B, and there is no interest, and a board can require lump sums, but if they want to, they can allow you to pay it in installments. So we probably, I was prompted to say this. Probably there's a veterans presentation in our sort of near future. We're lining up the different quarters for next year and what we're going to teach on, and veterans looks like something that it is going to come up. Next slide, please. So regarding the military leave, you look at the USERA. USERA basically keeps you whole. You can't lose any credit that you would have gotten had you not been summoned away to military service. So, ready to go on to scenario 6.
All right, thanks, Judith. So in scenario 6, we have Sammy Educator had a job he loved. He worked in the Quabbin Elementary School. In June of 2018, after a long and illustrious career working in the elementary school, he retired from the only job he had ever had. He retired as a member of the Quabbin retirement system. Next slide. So after a couple of months of playing golf, traveling, brushing up on Chapter 32 of the Massachusetts General Laws, and of course the community bus trips to the local casinos, Sammy realized that come September, he would not be returning to school. This prospect frightened Sammy. He asked if his position at the school was still available. Sadly, the school had already filled the position. Sammy Educator was devastated. Next slide, please. Now, Sammy had heard about an opening at the elementary school in the next town. He applied for the job and was hired. This new job paid twice what his old job paid, so Sammy was ecstatic. Because he had been brushing up on Chapter 32, in which retiree doesn't, he knew he could work the rest of 2018 with no issues. He also knew that he could work a few months of 2019 without violating the hours and earnings limitations of a retiree from a Chapter 32 system. Sammy really didn't want to waive the retirement allowance that he had worked all of his life to receive. Next slide. So one Saturday in 2020, during his self-imposed quarantine, Sammy was doing a little light reading of Chapter 32. Now, surprisingly, he fell asleep while reading Chapter 32. In what could only be described as a miracle, when he awoke, Chapter 32 was opened up to Section 105. Sammy's interest was piqued. He decided, this is what I'm going to do. Next slide, please. So Sammy is going to reinstate under Section 105. So the quiz question, and I believe there's only one for this scenario, is when does the reinstatement service under Section 105 begin? Is the answer A, it starts on the last day Sammy worked at the Quabbin Elementary School? Is it B, it starts on the day he begins work in the new school? Or C, it starts on the day Sammy signs the Section 105 application?
Okay, everyone, select your answer and you will be able to pick A, B, or C. All right, I'll be closing it out in about 5 seconds.
Okay, and that looks like it's another split decision. And the answer in this case is C. The reinstatement service begins once he signs the application for the Section 105 reinstatement. Next slide, please. So Section 105 is one of the relatively new sections that was added to Chapter 32. Essentially, it allows someone who was retired for Section 5 or Section 10, which is a superannuation retirement or a termination retirement, to be reinstated to active membership in a retirement system. In order for a person to be reinstated under this section, they must repay back all of the retirement allowance they received plus buyback interest to the retirement system from which they retired. Once they do that, they must work another 5 years of reinstatement service in order to retire and take advantage of the provisions of Section 105. So what the advantage would be is if they do perform 5 years of reinstatement service after reinstating to active membership, they can re-retire from whatever system they're working in at the time, and they would get credit for all the service that they had under their original period of service. If they do not work the 5 years of reinstatement service, then they would receive all the money they paid back to the original retirement system, and then they would start to collect the retirement allowance again at that point from the original retirement system. Does anyone have any questions on Section 105 before we turn it over to Judith for scenario 7?
Yes, I have some questions here. This one question is going back to a previous section. If someone was erroneously admitted, why are they not mandated to join the system?
I'm not sure I understand the question. If they were erroneously admitted?
I think it should say omitted.
Oh, omitted. Why are they not? Yeah, membership is mandatory for the people who fulfill the membership requirements of a particular system. In general, all full-time service, I shouldn't say all, full-time service should be mandatory membership service, certain exceptions. So if you are supposed to be a member of the system, it's mandatory, not permissive. The only people who get to pick are elected officials.
Military time requires a DD-214 form. What form does PERAC require for reserve time?
I think you always need a DD-214 form because you have to prove you were discharged and discharged at least under honorable conditions. If there's another form that's needed for reserve time, I'm sure one of the members of the legal unit will text it to me on my phone. But I'm not I don't know the form name. But if it gets texted to me, I will share it with you.
Okay. This is
I'm
also for the previous section.
Yeah. I got my phone here in case somebody wants to send me something. So, but you gotta have the DD-214.
Okay. Doesn't he have to return to the same employer within 2 years of discharge to get the free service?
I don't think so.
I think this is going back to the 401H.
Yeah, I missed this. Sorry.
So. Yeah.
Whoops.
No.
I thought the 180-day notice is you have to return the 401H form by 180 days, but not required to start the purchase.
Yeah, I mean, the 180, this is a section of Chapter 32 that requires notice, and there are many bills currently pending to change that or to make it a little more equitable. But I think you have 180 days to say you will buy the service. You don't have to start buying the service after the 180 days.
Okay. Okay, and now this one is for the reinstatement, and bravo for the storytelling. Good job. Doesn't the reinstatement form not only have to be signed, but also be a completed form?
I mean, I
So,
would say yes, it should be completed, but
yeah. It does say at the top of the reinstatement form, the most recent one, the reinstatement date, entry date, earliest date, and amounts are estimates. Final dates and amounts are dependent on the date that this form is signed. And like John, I would think that you'd have to fill out the form
before
in order
signing
to
it, right?
sign it. Yeah.
Does a reinstatement person that goes to another system, are they new members after 4212, and is their contribution rate 9%?
okay. So the answer to the first question is they would be whatever type of member they were in the prior system. Under Section 105, a person doesn't sever their membership. They become members inactive as retirees of the system, and then they become members again. So they've never severed their membership. So even though they may come back after 2012, April 2nd of 2012, they wouldn't be considered post-4212 members unless when they, under their original retirement, they were already members after April 2012. And obviously those people aren't going to be returning to service under Section 105 as of yet. Now, as far as the contribution rate, Section 105 says when you reinstate to service, your contribution rate is whatever it is at the time you reinstate. So currently it's 9%. If the rate were to change down the road, it would be whatever the new rate is in effect at that time. You do not get to keep the same contribution rate you had before you had retired.
But I love how a retiree remains a member, and that's why you get to stay under the old plan you were on. I don't know how many of you are old enough to remember the Perry Mason show, but in Perry Mason, he'd be sitting there in a case, and then somebody would rush into the courtroom with a piece of paper that explained everything to him. Similarly, somebody just rushed into the conference room here at PERAC with some breaking news about the veterans forms. So I want to tell you that we accept Form 256 for reserve time and Form NGB-22 for National Guard time. There are also reserve retirement credit forms from military that can be used for total reserve and National Guard time. So I hope that answers your question. And I've received this on two different, electronically and by a piece of paper. So reserve.
You have some good people on your team.
Yeah.
All right, a few more questions.
How do people do this without little pieces of paper and a cell phone?
Should the board that has the prior service with not transfer the funds and service to the current board until the 5 years have passed?
Yes, that's what we recommend for the retirement systems is, so the retirement board where the member originally retired from, they would have control of the annuity savings fund account at that time. We recommend not transferring that money to the new retirement system until the 5 years of reinstatement service have been earned. Otherwise, if you start transferring the money early and the member doesn't work the 5 years of reinstatement service, then money has to get transferred back, and they'll be fighting among the interest that was transferred over and how much interest gets sent back. So to avoid the headache, we've recommended that retirement systems do not transfer the annuity account over until we're sure that the member would be retiring under Section 105 from the new retirement system.
If a Section 105 member works the expected 5 years, is there a scenario where a 7-year spike window would be in play?
There could be, yes. Currently, anyone who is considered a post-4212 member, their retirement allowance is based on a 5-year average salary. So if you have someone who was originally a post-4212 member, then you would need 7 years of salary in order to determine the spiking for the last 5 years. And also, if anyone violates Section 14 of the anti-spiking provision, so it's Section 14 of Chapter 176 of the Acts of 2011, That section basically says it's in your last 5 years of creditable service. If your pay more than doubles between any 2 consecutive years, then the benefit is based on the average of those last 5 years. So if you have someone who returns under Section 105 and violates Section 14, then their new benefit would be based on a 5-year average. And again, you would need 7 years of pay to complete the spiking look back.
Okay, if they buy back the time they worked between retirement and reinstatement, does it count towards the 5 years?
No, it does not count towards the reinstatement service, but it would count as creditable service when the member goes to retire again.
Every city and town has a veterans agent. Ask them about the best form for reservists and guardsmen. I guess that's just a statement.
Thank you.
And I think, Judith, you answered this one. I heard that the National Guard requires NGB Form 22. Is that correct?
Yep.
Okay. Under Section 105, if the member only works an additional 4 years after reinstatement, then what happens to those 4 years that he or she contributed after reinstatement?
Well, the contributions that they paid to let's assume the second retirement system would get refunded to the member. And then the original retirement system would repay all the money that they received from the retiree under Section 105. And then the retiree would continue to receive the original retirement allowance from the original retirement board.
Okay, and the next question was similar to that. But part of it is the retirement benefit calculated using the employee's new age? And
If
do they
the
have
member
the option of
works,
refunding?
let's answer the first question first. If they
Okay.
work the 5 years of reinstatement service, then yes, they would be treated as a new retirement allowance. So you would look at the age of the member when they're retiring the second time, but they would also get credit for any salary that they would have earned after they had unretired and reestablished membership. To go back to the first question, I don't know why a person would go through the hassle of a Section 105 reinstatement if the plan is to work 5 years and then not take advantage of it.
All right, and we'll take a couple of questions and then we have to move on just in the interest of time. Reserve time can only be purchased on a prorated basis if it is in conjunction with active duty, correct?
If it's in conjunction with active duty, I think reserve time is purchased on a 5-to-1 basis. I don't know that there's any. I'm sure it's in conjunction with active duty.
And I understand that a retiree that hasn't been reinstated is working post-retirement. So how can a retiree purchase the time before reinstatement and add it to creditable service?
I believe there's language in Section 105 itself that allows that. We'll go back and we'll double check. If whoever sent that question could email either Judith or I, we'll review that for you and we'll get an answer out to you.
Okay.
We got to. I think we got to move on though because we've got to finish in a half hour and we have 4 more scenarios to go through.
Right.
Unless there's a. I think I'm grabbing from this and it's very helpful that a Section 105 training all by itself would be helpful. So this is very good. I just wrote that down. I think that this calls for that, but we can't spend a whole lot more time on that and not get through all this.
I have just one quick question. If they get the refund, do they receive interest on the monies that they contributed if they don't qualify or don't work the 5 years?
Again, I believe interest is included in Section 105, but we'll have to take a look at that one too.
Okay. All right. So we'll take other questions if we have time available. Thank you all for
thanks for being so engaged. Yeah, and it's very helpful to know what the interest is and where the need is for information. So definitely now we have a liability training and a Section 105 training that we can think about. So let's quickly go through the rest of the scenarios. Scenario 7. Susan Esposito worked for the Johnson County Library full-time for 4 years. She withdrew her funds on termination from service. Later, she became employed with Magoffin County Library full-time and left after 7 years of service, but left her money in. She has approached the Magoffin County retirement system asking to buy back the Johnson County time. Susan currently works for Raytheon. So the quiz question on this one is, can Susan, such an inactive member, she works for a private entity, purchase the 4 years now? A, no, Susan needs to get a public job covered by Chapter 32 before she can do this. B, yes, Susan is inactive, but she has the right to redeposit this money at any time before a retirement allowance becomes effective for her. C, no, this would be an unfunded liability for Magoffin County. D, yes, but she needs to pay back Johnson County. So quickly, may she purchase 4 years even though she works for Raytheon now and is in the private sector?
All right, is it A, B, C, or D? I'm going to give you exactly 30 seconds to submit your response.
So this is
Majority
really,
A.
yeah, this is very interesting. Many of the people in the audience will remember that the issue of whether an inactive member can buy back time has been a vexing one throughout Chapter 32 history. And Crabb, in a 2015 decision in Zavaglia, which was not appealed, made kind of a definitive ruling on inactive members buying service. Generally speaking, the ability of an inactive member to buy back service is extremely limited. But in that decision, Crabb left open the possibility of somebody like Susan Esposito, who has time in a board, takes it out, goes to work in another town and doesn't take it out. She has the right, until a retirement allowance becomes effective for her, to put the money back in. So in a shocking turn of events, the answer to this is B. Yes, Susan is inactive, but she has the right to redeposit this money at any time before a retirement allowance becomes effective for her. So this is a very big, I don't want to call it a loophole, but it is something that was in a footnote in the Zavaglia case, and you can purchase back under 36D at any point before a retirement allowance becomes effective for you. So that is that is set out in slide number 46, and this is why Susan, though currently employed at Raytheon, may be able to buy back this time if she so desires. It's very interesting and a very definitive decision from Crabb that was very helpful. And now scenario 8.
Okay, now as I read through scenario 8, people will see when I started to get tired coming up with these different scenarios. So I do want to mention there is a typo in scenario 8 in the first bullet point. At the end, when he stopped his employment, he's going to withdraw his money. He's not going to leave it in. So we have Bradshaw. He was a full-time member of the Pondville retirement system from September 91 through June of 96. As I mentioned, he took his money out of the retirement system. He returned to work as a substitute teacher in the Shiny Lake Public Schools, which is a member unit of the Pondville retirement system. And we show his earning history for the 5 or 6 years that he worked in the Shiny Lake Public School System. The Pondville Retirement System, although we don't say it here, has a rule that does not allow substitute teachers to be members of their retirement system. Next slide. In 2013, he becomes a full-time employee in a different position covered by the Quabbin Retirement System, and at that time becomes a member of the system. The Pondville Retirement System, it says he transferred his funds, but since he took his money out, we'll have to remove that last sentence also. So Brad would like to purchase his service when he served as a substitute teacher. So next slide. So the first quiz question is, can Brad Shaw purchase his substitute teacher time? And the answers are yes, under section 3.5. B, yes, under section 410. C, yes, under section 4.2C. Or D, no, he cannot purchase his substitute teacher service.
Okay, everyone pick your letter. 30 seconds.
Okay, and for this one, the answer, even though most people pick D, the answer for this one is actually A. He can purchase the time under section 3.5, and we'll look at that in a second, but we do have a couple of more quiz questions. So I did get tired of writing summaries of our fictional people, but I did not get tired of writing quiz questions. So the next question we have is, who would be liable for the service that he's allowed to purchase? A, the Pondville Retirement System, B, the Quabbin Retirement System, C, Bradshaw himself, or D, the Shiny Lake Public Schools.
20 seconds for this one.
And the answer for this one is B, as we'll see in a second. And the last quiz question. Are there any other things that we need to consider? Answers are A, yes, anti-spiking under section 14 of chapter 176 of the Acts of 2011. B, yes, section 410. C, yes, what happened to Carol Baskin's husband? And D, no.
All right, everyone, 20 seconds.
And I agree, we do need to know what happened to Carol Baskin's husband, but yes, the other thing we would need to consider is section 410, because some of the pay that the member received was less than $5,000. Of course, we would need to consider anti-spiking if and when the member ultimately retires, but that really is not affected by this because it won't be his last 5 years of creditable service. So next slide. So here's some language from section 3.5 with which Judith spoke about earlier. So in this pre-membership service, which is temporary, provisional, or substitute, and a substitute teacher is in fact a substitute position in a governmental unit other than that by which the member is presently employed, can be purchased under section 3.5. And the service is taken on by the system where the purchase is made. So where the member is presently employed would be responsible for the service. That's why the answer to the second quiz question was section B. And with that, I will turn it over to Judith for scenario number 9.
Thanks, John. So we have 2 more scenarios, and we're going to be good. We're going to be good on time. I think we'll have time for a little more questions, too. So Samantha Davenport, a member of the Syersville Retirement System, is thinking about retirement. She once worked for the town of Dalton, which has its own retirement system, as we know, but withdrew her funds, which amounted to 7 years worth of creditable service. She has 29 years of service and needs 3 more years to make it to 80%. She comes to the retirement board office and asks to purchase the 3 years. So the quiz question is, may Samantha purchase the 3 years of service? A, yes, because she only needs 3 years to get to the maximum. B, no, because the law requires any amount withdrawn be repaid in full. C, yes, but she has to pay the most recent time first. D, yes, but it doesn't matter whether she pays the most recent time first.
Okay, everyone, select your answer and you will have 20 seconds.
Okay. Well, the answer is, as most of you said, B, because the law requires that the entire amount withdrawn be repaid in full, which will be featured on the next slide, how much time needs to be repurchased. You can see the redeposit of withdrawn funds, the entire amount has to be repaid. And it's lump sum or installment payments not to exceed 5 years, depending on what the board desires. But when you redeposit previous withdrawn funds, you have to do the whole amount. Contrast that to the buyback of prior non-membership service. And this is where the more recent time comes in. If you're going to buy back prior non-membership service, you can buy back littler increments, smaller amounts. Maybe she could buy back the 3 years she needs to get to 80%, but you have to pay the most recent time first. So these are the, this is the PERAC regulations at 840 CMR 15, and that is the story of how much time needs to be repurchased. And so we'll go to slide 56, which has the language of section 38B, and which requires the entire amount withdrawn to be put back in if you want to make that buyback. And unless there are any questions about that, which apparently there won't be since most people got that answer correct, I'll turn it over to John for the final scenario.
Yeah,
Okay,
we're going to
and
take questions at the end just to make sure that we have time to finish the presentation.
That's a good idea. Thanks. Thanks, Natasha.
Okay, now as people will be able to guess from scenario 10, I in fact did not write scenario 10 because it fits on one slide very nicely. So in scenario 10, Louis Lipset works for the city of Berlin, which is known affectionately as the city that paper built, and he worked for the athletic department for 6 months after he graduated from high school. Louis left Berlin and America, in fact, for some time. And while he was away, the athletic department was flooded by molasses and all records were destroyed. So now Louis wants to buy back his 6 months of time. So next slide, please. And so we'll also only have one quiz question on this. It's assuming this time is otherwise eligible for purchase, may Louis buy back the time? Yes, he shouldn't be disqualified because the molasses flood wasn't his fault. B, yes, because the time was earned fair and square before the flood. C, no, the burden is on the member to prove entitlement to the time. Or D, both A and B.
Okay, everyone, decide which one you will select, and you will have 20 seconds. Oh, great participation for the last question.
Mm.
Okay. So yes, the answer to the scenario as presented was C. But as we will see from the next slide, there is a way that Lewis would be eligible to buy back the time.
John, can I just jump
So,
in here and say that when you get your little packet of opinion letters, this won't be in there. We didn't base this on an opinion letter. To my knowledge, we've never had a question about a molasses flood before, but please continue, John.
it's okay. Yeah, we needed enough scenarios so that we each did 5, and the work that Felicia had done had only included 9 different scenarios. So, so on this slide, the lack of documentation or proof. So the member has the burden to establish the right to purchase the service. So now, what happens if the service was so long ago that there's no documentation available? If the member can come up with affidavits from prior colleagues, newsletters indicating that he served as the athletic director during a period of time, Social Security statements indicating that he was paid for 6 months of time, these could be used to allow him to purchase the time. So going back to the quiz question, in the absence of any other documentation that can establish that he did work as the athletic director, no, he would not be able to buy the time. And so next slide, please. So now all good presentations should have a conclusion slide, as Judith will attest to. So we've gone through 7 different examples, and we've shown that many considerations come into play when a member seeks to purchase creditable service. The facts of each case are unique and will need to be examined to determine whether the member is eligible to purchase said service. Chapter 32 and the rules of each board will determine which time is eligible for purchase and under which conditions the purchase can be made. Now, with that being said, we'll open the floor up to some questions for the remaining time that we have, if there are any.
Yes, we have a few more questions. Thank you, John. If a board has a policy to not accept liability for service performed in positions outside of its jurisdiction, can buyback of substitute teaching service be denied?
Judith?
I think that's a 3.5 question. And the one thing to remember about section 3.5 is that it says shall. And if you come in and there's 3.5 eligible time that you can buy back, the current board has to let you make the purchase. You know, 3.5 is very limited, though. We've said that throughout this presentation and throughout all of time. And it's very hard to have 3.5 fit into a buyback. But if it does, the current board has to do it. It doesn't matter if the former board accepts liability or not. And again, I'm really looking forward to our liability presentation. And I think we'll be done by the actuarial unit, right, John?
Right, Judith.
Okay.
What section of the law requires a member, once they rejoin a system, to have to work, once they rejoin a system, have to work for 2 years before they retire?
That's the 2-year rule. I think it's somewhere in the 3s. The wrong section here.
I think it's 36D or 36E, I believe.
Okay. So I'm going to look up.
Might be
I'll read the
36C.
next question.
Yeah, I'm going to look it up and we can. I think John is probably right.
Okay. During a redeposit, if the member retires before the installments are complete, the service can't be prorated?
Oh, gentle reader, gentle looker on of this presentation. We don't like to bring that up, but that is a loophole you can drive a truck through. So if you have a member who is, and if somebody wants to text me the 2-year rule citation, that would be great. If you have a member who is going to redeposit their money and they're going to do it under a payment plan, and their payment plan isn't complete at the time they retire, you do indeed prorate the service. And the service proration, that award of service will only be granted upon the retirement date, upon the time of their retirement. While they're paying it along, it isn't considered complete until it's done completely, until you've done the whole amount. But if you've only done a partial amount by the time a retirement allowance becomes effective, that is indeed prorated. Very good question. We don't like to bring that to people's attention, but it is, it's something that everybody thinks about. And certainly we in the Chapter 32 business are wise to that.
Okay, if Section 105 member does not work the 5 years, i.e. if they are not reappointed, is the original retirement benefit recalculated using the original salary, original service with the member's current age?
No. Under Section 105, if the member does not complete the 5 years of reinstatement service, they go back to receiving whatever allowance they had originally gotten. So the allowance isn't recalculated at all. It's whatever the original benefit was gets repaid back to the member starting up after they cease working in the other system.
Okay. In the case of a reinstatement, in bookkeeping, do you transfer their annuity reserve back to annuity savings in the original amount, not including interest?
This is a great question for the audit staff who handles the accounting in Chapter 32. As the actuary, I don't know about the accounting to the different funds, and I'm pretty sure Judith, as general counsel, doesn't know about the accounting
I'm
of
busy.
the funds.
I'm busy looking up the 2-year rule, which I have. Correct. It's Section 36E.
Okay, and I had a question about page 2 of the presentation. Can you give a brief summary of the buybacks on the sections listed on page 2 of this handout? Sometimes reading Chapter 32 is not that crystal clear, and the attorney language is confusing. So let me see if I can get back to page 2 quickly.
Is that the one that lists the sections most likely to be used in buyback? No.
Yes.
The one or the one before it?
It's the one before it, Judith.
Okay. So there's 2 main types of service purchases. Basically the redeposit of withdrawn time and the payment of earlier non-membership time. And I do think the next slide would be helpful because it tells different sections. So Section 3.3 is
sorry.
Okay. Section 3.3 was obliterated in terms of elected officials with the recent elected official decisions from Dowler and Crabb. But Section 3.3 allows you to buy back time from when you were eligible for membership and should have been a member and didn't. And principally, elected officials rode on this section until the 2012 era. 3.5 is the buyback of prior non-membership time from a different board. But as we've tried to emphasize throughout this presentation, that's really limited. It's really limited to substitute, temporary, and provisional, I believe. 3.6C, 3.6D are about redepositing money after you've left service. I think 3.6C, if you come back within 2 years, 3.6D if you've come back outside of 2 years, and different rights blossom depending upon whether you make the buyback within 2 years. And 3.8B is your classic redeposit scenario. And 3.8B, it should be noted, is where you should really try to make the payment within the first year you're back, because the interest really balloons after 1 year has gone by. Under Chapter 176 of the Act of 2011, Section 9. So try to make a payment within the year, or you'll go from buyback to actuarially assumed interest. The section 41H is military. 42B is a lot of different times. When we see 42B, we always think of reserve police officers, call firefighters, but actually there's a lot of people mentioned in 42B, including our friend, the seasonal worker, and so there are a lot of different, remember, the Supreme Judicial Court now considers 42B to be a measurement scheme. So that's where the provisos about call firefighter are. That's where the provisos about seasonal employees are. 42C is our most expansive ability to buy back time because it runs the gamut, part-time, provisional, temporary provisional. There's all sorts of categories in there. But you have to buy back from the same board of which you're currently a member, and the board has to have a rule in effect that says you can do that. Section 25C3 is about correction of errors. In many ways, it kind of mirrors Section 3.3 and Section 105, which my esteemed colleague has gone through extensively, is the reinstatement to service. The one thing I like to say about Section 105 is that 5.1G used to be the way back in for superannuation retirees. The only other way back in was Section 8 for disability retirees, which is still in effect. And for a short period of time, a couple of years, 5.1G remains on the books, but now it's subject to the requirements of Section 105. So it's kind of been consumed by Section 105. But for a little tiny period of time, 5.1G, without any requirement of interest, remained. And now, of course, all reinstatements for non-disabilities come through Section 105. I hope that answers the question.
Okay, thank you, Judith. I have
Sure.
a few more questions. We have about 4 minutes left, so I'm going to take just 2 more, and we'll put the answers to the remainder of the questions on the website just to respect everyone's time. Going back to the discussion of the elected official who, when re-elected, is not allowed to buy back prior service, what if the non-contributing elected official becomes a full-time employee and seeks purchase of prior elected service? I think Section 25 of Chapter 21 speaks to this to allow creditable service shall be granted if earning less than 5K after 7/109, if such service is as a result of an election.
John, do you want me to take that?
Yes, please.
Okay. It doesn't matter if they're a full-time employee, they still can't buy the time back. And if I got to make the rules, I would let them buy. I would let everybody buy back all time. I'm not paying for it. I'm not on the retirement boards. I don't have a duty and an obligation. But really, I think they should let elected officials buy back the time in these circumstances. But the recent decisions of Dowler and Crabb, starting with the AWOD case, say that that is not to be. And if you miss the 90-day window, you don't get to reawaken the 90 days by buying back the time in the past. And I personally, Judith wishes it were otherwise, but it is not.
All right, next question. Can individual boards have a rule that overrides that rule regarding full repayment of refunded service?
No.
If reinstated, does the member receive interest on new contributions only, or does it include contributions before they retired?
I'm not sure I understand. John, do you understand?
We can answer that one on the website, or if the person who asked the question, if you could add.
I believe when the person doesn't work the 5 years of reinstatement service, they're entitled to all money paid to a retirement system under Section 105, which would include the contributions to the current retirement system and then the retirement allowance that was paid from the original retirement system. I believe both of those payments have interest, but that's one of the things we're going to look into as to whether interest is paid back to the member if the 5 years of reinstatement service hasn't been met.
Yeah, we need to look into that. Yeah, go ahead, Natasha, sorry.
I was just, there's one more question, one final question. It says, if you could repeat 25C3, please. The short explanations are great.
The 25C3 is the correction of errors. So if you have a situation where a board needs to correct an error, people can purchase time under that section.
Okay, and that was the final question. We finished exactly on time.
As usual. The
Thank
PERAC
you,
presentation
everyone.
process. Yep. Thanks, everybody. Good to see you. And we'll
Thank you, everyone.
Back on.
All right,
Thank you,
bye.
everyone. Enjoy the rest of your day. And again, board members, if you're joining us live, you'll receive your credits automatically. No need to reach out to us. If you're watching the recording that will be posted to the website later this year, please submit a training affidavit in Prosper. Okay. Thank you very much. Enjoy the rest of your day. Bye-bye.